Good afternoon. This is Julia Graham, Technical Director at Airmic, and I'm welcoming you to this webinar on GDPR 2020. I don't know about you, but I find it quite amazing that it's now nearly 2 years since GDPR became live, and it was in May 2018 that this milestone in European data protection law came into force. Now, almost 2 years later on, what does the data protection risk and insurance landscape look like? Well, I think we're about to find out because we have three wonderful presenters today. First of all, Tim Smith, who heads up BLM's technology and media team and specialises in defamation, breach of confidence, privacy and data protection. Tim will be joined by Nick Gibbons, who specialises in technology, media and telecommunications, intellectual property, cyber risk, professional negligence and insurance. And last but by very means not least, we have Lindsey Nelson joining us from International Cyber Underwriting Team CFC. And I believe at CFC, Lindsey, you lead the cyber team for the business. So we have three amazing presenters today. What we're going to do is we're going to walk through a presentation. We're going to show you just here how you can ask questions as we go through the presentation. Please keep them flowing because this is the way that you're going to get most out of today's session. We have an hour. We're going to be recording today's webinar, and you will receive a copy of the slides that are being used, and those online will receive, and Matt will be messaging you a copy of the relevant white paper, which is also being published. So I think what we will now do is that we will start off on our trail. I think, Tim, turning first to yourself.
Smashing, thanks very much. Yeah, we've got quite a few slides to get through. I don't think Nick and I are going to sort of labour them. What we'll try and do as we go through is to sort of draw out the most salient points. So we might rattle through them slightly quickly, but hopefully they'll be available as a takeaway. And what we'll do for today's purposes is just highlight the things that are most relevant. That's quite a long list of topics to address. I'll take everyone through to the sort of recent case law section, then Nick will pick up on the GDPR fines and take it from there. But if we move on to the next one, we'll get going. Really, on this slide, it's just a refresher as to what the GDPR brought with it. I think the headlines there are really just the onerous notification requirements, the headline grabbing fines, but also underlying all of that, certainly from a practical point of view, was the fact that the GDPR reached more information and applied sort of more widely, both in terms of its sort of legal scope and to what the data it applied to, but also geographically. So it's a piece of legislation with much greater sort of scope than the previous legislation. That was something to be aware of right from the off. Yeah, if we go on. Yeah, one of the things I think we've noticed in this context is the relationship between the impact on what happens when you're dealing with crime. We flagged the sort of most straightforward crimes we deal with as sort of Friday afternoon frauds. There, I think they picked up that name certainly within our office on the basis that there was definitely a prevalence of attacks on solicitors' firms, particularly those dealing with conveyancing, and a lot of conveyancing transactions happened on a Friday afternoon. So the perpetrators had a good idea of that and focused in on that. But we're seeing these sort of payment frauds happening across all kinds of businesses and professions now. So it's not just something that's happening to lawyers. The difficulty can be sometimes when you're trying to establish how it happened, whether that, for example, is the customer who's been sort of hacked, or whether it's the business. If it's the business, it can be quite a fiddly process because you're trying to work out what the perpetrator had access to, and that affects the reporting requirements. So the crime doesn't just mean that you as a sort of first party are affected, it can mean that there are wider impacts and those are relevant to notification. Yeah, happy to go to the next one there. All of that sort of impacts on costs. I think sometimes it's overlooked that the cost of dealing with an incident can be quite significant, but because of the need to try and find out exactly what's happened, what the perpetrators, particularly on, say, a criminal incident, have had access to, that can be quite difficult. So, for example, I've got a matter on now at the moment with the guys at CFC where the IT forensic experts are trying to identify sort of the footprints that the perpetrators have left in a system so we can see what's been accessed, because that affects the advice we'll give on who needs to be notified, both in terms of the ICO and the individuals who might have been impacted. The other, I think, thing to flag is just that quite a lot of information needs to be provided to the ICO, so you have to do quite a lot quite quickly. In that context, it is useful, I think, to, and I would say this perhaps, but it is useful to have the lawyers involved, because we're seeing, and we'll perhaps touch on this later, but we're seeing claimant lawyers ask for the notification details. So what they're asking for is everything that's been sent to the ICO, and because that can include quite a lot of information about the incident, quite a lot of technical information, that can be quite a handy use sort of document in the hands of the claimant. So we're trying to take care about exactly how we pass on information to the ICO where we can. Yeah, happy to go to the next slide there. In terms of the impact that we've seen on sort of claims, we'll touch on this in this slide and the next one. Really, I think in some ways the thing to bear in mind is that if you've got greater rights for individuals and sort of greater awareness, because so many people have gone through their sort of data protection training, there is that awareness of the obligation on organizations. Individuals are more aware of their own rights under the GDPR, and because of the nature and extent of the GDPR and the fact that it is quite a broad piece of legislation, there are going to be more incidents. There are going to be more criminal incidents that might be covered, but there are going to be more human error incidents as well, and that's going to give rise to more claims. That's just I think the way it is. One of the challenges around this is that a lot of the claims are worth a very modest amount, but you've got a lot of people who have some awareness of data protection and quite often represent themselves, and that can produce its own complications. In fact, there's an extent to which one might say that you'd rather they were represented sometimes, simply because dealing with a litigant in knowledge, litigant in person, he's got a certain amount of knowledge, can take a longer period of time than when you're dealing with a represented party. That's probably that for this slide. And yeah, the point to flag on the next one, I think, is as well that we are seeing more claims being brought normally by parents, but on behalf of children. So if you've got a piece of information that might affect a family, we do a lot of work in the sort of health and education spaces and for local government, and we do see that you get sort of a whole sort of family group bring a claim. Claims from children can be fiddly, not only in the terms of sort of verifying identity and representation, but also there are special rules around getting court approval for settlements, and those can be fiddly. There are some sort of practical workarounds, but that can increase costs. Yep, that's it for that slide. Subject access requests I know are a bit of a nightmare for everybody. They were reasonably well used under the old sort of Data Protection Act 98 regime, but again, perhaps tying into that point I made before about increased awareness by individuals of their rights. We're certainly seeing them used. Claimant solicitors love them. They're sort of effectively weaponizing them to use them to obtain pre-action disclosure. You can get quite a lot of information very quickly, very cheaply, so they're ideal for that. We see them particularly in context of employment-related disputes. So if you've got someone, say, in a legal practice, if someone like me who's been at a firm for 20 years will have a huge sort of footprint within the firm. If I fell out with the firm, there's a huge amount of information that would be captured by a subject access request. This is no longer the sort of credit monitoring, sort of mass marketing type of information. It's sort of substantive information. I think a lot of organisations are finding it very hard to cope with the volume of subject access requests and also the amount of material that a request will generate. So certainly something that we're seeing more of. And again, against that backdrop, I guess it's no surprise that claimant lawyers are looking at this area. Part of that is just the wider economic sort of position that certainly, say, lawyers who historically specialised in personal injury or conveyancing or probate are finding that their traditional forms of work are drying up or are not as lucrative as they used to be. You've got all kinds of sort of people providing services around wills. You've got licensed conveyancers doing sort of volume conveyancing work, and injury is affected by the removal of success fees and the introduction of fixed fees and portals. So claimant lawyers are very much looking for somewhere to go. A lot of them have seized on this as an area they want to get involved in. Interestingly, as an aside, under the old legislation in the period, say 2000 to 2015, we rarely saw any injury claims in this sort of context. What we've seen in the last couple of years is claims for sort of psychiatric injury accompanying claims for breach of the Data Protection Act on the basis that the distress caused to an individual has reached such a level that they've suffered a sort of psychiatric injury. That we're pretty sure that overlaps entirely with the arrival in this realm of claimant law firms with personal injury expertise. They're often much more sort of comfortable with that area than they are in the areas of sort of data protection, breach of confidence and privacy, which are at the heart of claims like this. That's it for that slide, I think. And then just, sorry, my sort of last couple of comments. Sometimes these cases take a little while to permeate through. We're not getting a lot of guidance from the courts on quantum. That's partly because historically damages have been relatively modest in claims like this, and there's an extent to which it simply isn't worth taking anything to a sort of substantive hearing when quantum's a few £1,000s. The key decisions I flagged there are Lloyd and Google. The claimant markets got incredibly excited about Lloyd. Two main reasons for that. One is that it translated over a concept of sort of loss of control of information that we've seen in privacy cases. Now you can see very clearly why that might be relevant in say a phone hacking case where you've got a celebrity whose information's been hacked and it's been put into a newspaper, because in those sort of situations that information has a tangible value because it's kind of information the newspaper would pay for. We've seen it as well in the sort of cases involving Google, where the sort of scooping up and monetizing of data has clearly got a value because Google's sort of business model to some extent relies on the ability to harvest information. So in those cases, the court was able to say, well, this information plainly has a value. Now that's less appealing when it comes to sort of the more anodyne types of cases, if you're dealing with details of people's sort of names, address, email addresses. But it is an unhelpful decision to the extent that slowly but surely we started with claims just for damage, but now it's damage, distress, and now it's damage, distress, and loss of control. Lloyd and Google is also important because it shows that the claimants are trying to bring sort of class actions in the UK. Those have been relatively few and far between, but the fact that the court permitted a representative action to be pursued was of some concern. That's on its way up to the Supreme Court if they take a different view. Morrison's, I know, has got a lot of attention, so I won't dwell on it too much. I think the only thing to say there perhaps is that it's perhaps not as bad as it looked. The boundaries of vicarious liability have been pushing and pushing out for a very long time. The High Court and the Court of Appeal both imposed vicarious liability on Morrison's, but with a bit of a sigh of relief, the Supreme Court decided not to. It's still on the outer perimeter, though, that in the most incidents, there's no argument that the employee was off on a frolic of their own and what they were doing was so detached from their employment that the employer shouldn't be liable. So it's not particularly time to sort of get out the bunting yet, but hopefully at least it pegs back what had been a fairly relentless drive to increase the liability of employers in all kinds of situations which can't be bad news. And I think that's
Tim, before you sort of finish on that point, you said it's not quite time to get the bunting out. However, does the Morrisons' decision mean that we can actually relax a bit now?
I don't think so. I think Morrisons initially came as a bit of an unwelcome surprise to the sort of tech cyber market, because we don't really deal with vicarious liability very often, and it seemed extremely unfair to find yourself saddled with liability for an employee who'd gone so far as to sort of do something that landed him in jail for a few years. But whilst the court has said that kind of situation, you're not going to be liable for the employee, in the vast majority of cases, employers will be. If you're dealing with an employee who just does something silly or stupid or negligent, you won't have the argument that Morrison's had, that you've got someone who's off on a complete frolic of their own. You'll be in a situation where the court will say, no, you are vicariously liable. So it's good news, but it won't have substantive application, I think, in the vast majority of claims, certainly not the ones we deal with. I think Nick and I, we reviewed our sort of portfolio when the decision came down, and we've got maybe one or two cases where we've got people who have done something that may put them outside the scope of liability for the employer.
Now, I'm not sure if this is quite the right place, but we've got a question that's come in, and you'll have to guide me as to whether this is for you or for perhaps even Lindsey. But one of the questions we've got is, so what's the position, therefore, on the moment about class actions in the UK? Is that something you can comment on in the context of GDPR?
Yeah, and Lindsey, if you want to chip in, do so. But from a sort of lawyer's perspective, we haven't got such a sort of claimant-friendly, I guess, framework in the UK. You've got two options in terms of class actions. One's a group action, and one is a representative action. The trouble with group actions from a claimant point of view is they're opt-in, which means that as a claimant lawyer, you have to go around sort of harvesting potential claimants, and you have to do your marketing, you have to get people to sign up. Representative actions in the UK are more like US class actions, where it's opt-out, so effectively you're in unless you decide you don't want to be. And for example, in Morrison's, that would make the difference between what they did have, which was 5,000 people, and what they could have had, which would have been about 100,000. So from a sort of defending these claims perspective, it's an important distinction. The challenge is the claimants have got very excited about representative actions, but they are very hard to get off the ground. That's partly because there are all kinds of technicalities around them. It's not a type of claim that we've seen used very much in the UK in the last sort of 30 or 40 years. They're very rare. One of the factors is you have to have really suffered the same damage as the claimant. And the argument in a lot of data breach cases is individual claimants will have very different experiences. So, for example, in Lloyd and Google, when the High Court didn't allow the claim to proceed initially, one of the reasons for that was that if you were getting bombarded with sort of targeted advertising, if that was about if you had been searching for a new fridge and were getting deals on fridges, you might be really happy. Ditto a holiday. But if you'd been searching for medical information because you'd just been diagnosed with something and you hadn't told your family, and that was being projected on your laptop or tablet, you might be pretty cheesed off. But you didn't have that sort of communality of interest. So we still don't seem to have a culture where people are that keen on group actions, and some of the procedural rules and requirements mean that it can be quite difficult to get them off the ground.
Now, I've got two other quick questions, Tim, before you duck out, and these are sort of directed at you, if I may. The first is a short question, and that is whether or not you've got a view on Hayes Connor dropping the Atkinson claim against Equifax.
Yeah, we come across them a lot. I think on first name terms with quite a lot of their lawyers. It's quite interesting. The underlying claim, there's not a great deal of information about it. Very interesting that they trumpeted very early on that they were bringing a representative action against Equifax. I think their website or the publicity material suggested it was for £100 million or so. Speaking to some of the barristers involved fairly recently, certainly on the defence side, they were a bit sceptical about that because the claim form, I think, pleaded a much lower figure. It's not clear what the sort of dynamics are behind the decision to drop the claim. There hasn't been a great deal of information out. It may well be that there's a vicarious liability point in there. It may be that they're concerned about what Lloyd and Google might do in the Supreme Court. It may be that there are funders involved. Certainly, if there were ATE insurers involved in pursuing the Morrison's claim, it's not beyond the realms of possibility that if they've taken a big hit, their sort of appetite for getting engaged and funding data protection claims is diminished. But yeah, it's good news that they've decided to row back on it, because certainly Hayes Connor are one of the more aggressive firms we come across, both in terms of, well, not so much Vanessa in terms of how they pursue the cases individually, but in terms of their willingness to take claims on a sort of conditional fee agreement.
And I'm going to ask one other quick question before we move on and carry on with our journey, turning to Nick. And that is, this is in the context of thinking in the internal stages of grievance where a company is still handling a matter. And that is, our member is saying, well, is it merely enough then to say I'm distressed by a perceived unauthorized processing of data or disclosure? Are there any factors to consider in an assessment when you are still at that internal stage of grievance?
Yeah, I mean, I think the brutal reality is, yes, it is enough to say you're distressed. That is, if you've suffered distress as a consequence of a breach, that's enough to entitle you on the face of it to compensation. The only rays of sunshine there are probably that the court says there is a sort of minimal, sort of de minimis threshold. So if it seems, if you look at it and go, well, it's simply not rational that someone should have been distressed by this, then you can argue that. The problem is, whilst the court has said that threshold is there, we have no case law at the moment as to where that threshold is. So you'll be looking at, say, what kind of information was it? What was the level of sensitivity? Who is it given to? How sort of rational is the claimant's reaction to it? So if you're dealing with sort of, say, the name and address, when the name and address is in public domain, you might say, well, that's just nonsensical. But if it's about someone's medical condition and it's been passed to someone it shouldn't have been, an email's gone to the wrong place, you might say, well, and it's a person they sit next to, you might say, well, actually, that's more understandable. So the answer is yes, distress alone is capable of being compensated, but you look at the facts to see whether you've got an argument as to whether it's very, very sort of modest.
Okay, Tim, thank you very much. We're now going to move on. I think, Nick, you're going to pick up the trail at this stage. Is that right?
That's right. If we could, yes, we just moved on to GDPR fines. And what I'd like to say about this, I think for many businesses, apart from big multinationals, this has been a bit of a phony war. One of the major motivations behind people notifying so promptly and so correctly following a data breach since GDPR came into force has been the threat of a huge fine. But for the majority of businesses, the ICO simply hasn't fined anybody. It's just the big multinationals that have suffered. And I think that phony war is going to come to an end, and there's a number of reasons for that. The capacity to fine at the moment is in the UK is 4% of global turnover, or 17 million, is 20 million in the EU. EU data commissioners have so far issued a total of 114 million euros in fines, and in the UK we've had a number of big multinationals such as British Airways and Marriott potentially being fined. I mean, the ICO has expressed an intention to fine. It hasn't actually confirmed the fines yet. But notwithstanding what looked like eye-watering sums, the EU Data Protection Commissioner is actually arguing that the limit should be increased because businesses like Google can pay these fines so easily. It means nothing to them. It's not much of a deterrent. So it may be that in the EU that the limits will increase. Could we have the next slide, please? So, and similarly, I mean, as far as SMEs are concerned in this country, there has been a bit of a grace period, and as I said, not many businesses in our experience have been fined, but I think that's likely to come to an end. And what we've been noticing on notifications is that the ICO is gradually getting more tough and intrusive. They're asking more questions. When GDPR first came into force, it was a very light touch, and I think that's partly because the ICO is absolutely inundated with notifications. But I think as they get more sort of capacity to deal with individual notifications as time goes by, there will be more fines, just as there were following the introduction of monetary penalties under the old legislation, the Data Protection Act 1998. I think the other point to mention here is that the ICO is sympathetic to businesses that notify promptly, provide a reasonably clear and full report. I mean, I take account of what Tim said, that claimant lawyers are asking for copies of these, but nevertheless, I think if one provides an adequate report straight away, and it looks as though the business is getting on with the investigation and is going to notify any individual data subjects that need to be notified, then the ICO takes a sympathetic approach, and in many cases just closes the file after the original preliminary notification. Could we have the next slide, please? One thing that we're beginning to notice, and it's very early days, is that a number of businesses aren't satisfied by what the police and the ICO are doing in response to data breaches. This is particularly in relation to data breaches where someone in the business itself or someone close to the business has hacked into the business for commercial advantage. And what many of these businesses are considering, and some are actually doing, is instituting private prosecutions. So, I mean, because the CPS are not going ahead with these sorts of prosecutions, and the big thing about those sorts of private prosecutions is that you can bring a charge not only under the Data Protection Act, but also under Section 1 of the Computer Misuse Act, which is an old piece of legislation from 1990. But that enables private prosecutions to include a charge which may result in the imposition of a prison sentence. I mean, it can be very serious. Can we go on to the next slide, please? And the other interesting thing about the Computer Misuse Act is that you don't actually have to prove that the individual who's hacked into the system has done anything with the data. You just have to prove they've had unauthorized access. So it's much easier in a way to prove a case under the Computer Misuse Act than under the Data Protection Act. And there has been a recent case in the Court of Appeal brought by the pensions regulator against a company whose directors hacked into their own staff's accounts in order to manipulate the pension scheme for their own benefit, and the directors have got prison sentences. So it is a serious thing, and it's a serious deterrent. And I think for businesses, particularly those involved in financial services, it's useful for them to demonstrate to clients that they do take data protection very seriously and data security very seriously. Could we move on to the next slide, please? The other slightly peculiar thing that's happened as a result of GDPR is that it's the fact that personal data has become so much more regulated and protected has meant that businesses have realized how valuable it is to them. I mean, it's basically personal data for consumer-facing businesses is basically their goodwill. I mean, it's very valuable. And so what's happening when businesses are taken over or when there's a merger and an acquisition, a joint venture, businesses are taking advantage of the provisions in GDPR, which are much tighter between data controllers and data processors, to gain ownership and control rights over that personal data. So it effectively belongs to them. And I've had experience with quite a number of agreements where that's been a really thorny and long drawn out issue. Can we go to the next slide, please? Next slide, please. Hello. Thank you. So, for example, looking at the mandatory requirements in respect to contracts between data controllers and data processors, which are required in any contract between them, the processor has to ensure that the people processing the data are subject to the duty of confidence. The processor has to take appropriate security measures. And I think most significant in many of these negotiations is the fact that the processor has to delete all personal data or return it to the controller at the end of the contract, which means effectively that where you've got two businesses where one of the business would very much like to take the goodwill of the other, at the end of the agreement, it has to return all the personal data which it's been using on behalf of the other business. Could I have the next slide, please? This is the coronavirus seems to have created a rather peculiar environment, which is very good for cyber criminals, and which is conversely threatening many of the sort of key principles on which GDPR is based. And Tim's going to talk about those in a minute. But essentially, the widespread remote working from home is a lot less secure than an office environment. And I've seen some newspaper reports in which it said that cybercrime has increased fivefold as a result of coronavirus. And I personally have noticed a real uptick in cyber incidents in the last couple of weeks. The other issue is ransomware attacks on hospitals involved in fighting the virus, which I think illustrates how ruthless some of these cyber criminals are. And I've given a couple of examples there: Brno University in the Czech Republic, and a hacker group attacking the computer systems at the Hammersmith Medicine's Research Centre. So over to you, Tim, for the next slide.
So there's
you're muted. Yep. Sorry.
No, sorry, I'm there. Sorry, I was chatting away. There's some good guidance coming out of the National Cybersecurity Centre on this. As Nick said, it's a bit of a shame, but the criminals are criminals, and they're pretty amoral about these things. So they've been leaping on the opportunity presented by coronavirus to try out all kinds of scams. There's a lot of phishing scams out there. They're using anything with sort of government or World Health Organization headers they can to attract attention, and they're putting out emails with sort of purporting to contain information about coronavirus activity in a particular city or an outbreak, or there are sort of fake apps for tracking. So there's a lot of activity around there. They're trying to take advantage of known weaknesses in some virtual private networks on the basis that they know that perhaps people working from home won't have equipment or kit of the sophistication they will at work. The flip side, I guess, is what we've sort of flagged here, is that there's an awful lot of enthusiasm on the part of government and large organisations to harvest information in this context, particularly say for tracking people who've had coronavirus, which has generated its own sort of debate around privacy rights. I don't think anyone's quite bottomed those out, but both on the criminal side and on the sort of governmental side, there are people who want to use the technology to take advantage of the current situation, or to collate data to deal with it. I think over to Nick then on our last.
Yeah, and this has become a bit of a curious footnote, actually, because as a result of coronavirus, everybody's forgotten about Brexit, apart from perhaps from Michael Gove and Boris Johnson. But I think one's got to remember that at the end of this year, we are at the moment officially leaving the EU, and that means everybody's got to have a think about how that will affect GDPR and the Data Protection Act in this country. And there has been some muttering at government level about sort of watering down the UK legislation once we leave the EU. And I think this point has been made by many people that GDPR is a manifestation of the Hotel California principle, in the sense that you can check out but you can never leave. I mean, the fact is that UK businesses are going to go on doing a huge amount of business in the EU, and therefore they're going to go on processing EU data. And so the EU is therefore, I'm afraid, for anybody who's a Brexiteer, going to continue to call the shots in this context. And I think sort of as a simple way of approaching it is, I think one can basically assume that GDPR and whatever happens to GDPR in the EU is going to continue to apply in almost every instance to almost every business after we leave the EU. And I've set out in this slide what the EU requires. But I think it's in an uncomplicated way. I think one should just follow EU GDPR regulations and assume that they are going to apply in the future, and take note of what is required by the EU for businesses that do EU business. So that's really it from me.
Well, there's two things in there. First of all, I never thought I'd say this, Nick, but I felt quite relieved to see Brexit mentioned again at the moment. And the second thing I sort of referred to, that if you're an international business trading across boundaries, you can't forget the fact that you still need to think about what Europe does. And I think from talking to members, quite a few of them will continue to follow the requirements, whatever happens to Brexit. Now, just before we move on to introduce Lindsey, who's been incredibly patient to join us, I've got two quick questions I want to pose to whoever would want to pick them up. First of all, one of them is quite specific, and it relates to risk managers often need to send sensitive data, for example, employee details, to their offshore captive for underwriting purposes, and that data gets forwarded to UK and European reinsurers. Have you got any thoughts as to how GDPR affects this cross-border transfer of data?
Tim, do you want to take that?
Yeah, there's within the EU, it's broadly okay. Is the sort of succinct answer, I think. The two reasons for that: one is that the EU, obviously, the various countries have all signed up to GDPR and recognise each other's standards. The other side of it is that the insurance industry was pretty savvy when it came to GDPR coming into force in the UK and the Data Protection Act 2018, And in the course of the process of the Act, there was some quite good lobbying done in the background, with particularly the ABI. And there's a carve out for sensitive personal data, which is being used for insurance purposes, which will help a great deal of processing on the insurance side, particularly of that sort of medical and health data. The position always gets more complicated where you're shipping data outside the EU, and that will vary according to the recipient and whether the recipient standards are approved by the EU or not. If they are, you're probably okay. If they're not, you've probably got to do a bit more work around it.
Thank you. And then the last one before we do move on, you can look at this question that's come in through two different lenses, actually. The way it's been posed is that, do you think, as the FT suggested recently, that ICO enforcement of GDPR data law has been toothless due to inadequate resources? The poser of this question says BA and Marriott spring to mind. However, I've also heard this question posed the other way around, that is it reasonable, you know, if you're talking about duty of care of people and you do your best, then that's a good defence. And it could be argued that somebody like BA, for example, did all it could do to protect the data, and therefore perhaps this is an unreasonable situation where an organisation that's done its best is still being called to account for something it probably couldn't do very much more about. But perhaps if we could ask you to finally comment on ICO enforcement, and then we are moving on to Lindsey, and just to remind people on this webinar that we're going to continue to the top of the hour. So please stay with us, because I know Lindsey's got some really interesting points to share with us. But if you could just give a very quick response to that ICO enforcement question.
Should I do that one? I mean, it is interesting that I mean, both in the case of multinationals, naming their names, but when one actually looks at their security measures, in many cases they're not that great. In many cases, you find that businesses, big multinational businesses, are cobbled together from various different businesses, and they just haven't got around to information security. And similarly, on the sort of SME level, it's surprising, you know, when one's dealing with these incidents, how many businesses have, you know, sort of out of date Microsoft software which can't be updated. Computers which have got lots of vulnerabilities. It's quite surprising, and as I said earlier, I think we're coming out of the sort of phony war period, and I think that the ICO will get toothier as time goes on and less tolerant. At the same time, businesses are gradually improving, so that's what I would say.
Okay, look, thank you very much. I'm going to sort of close your session down there, and Lindsey, I'm now going to be turning to you. So if we can sort of get the next slide up, which I think you've got a couple of slides, and Lindsey, the stage is yours.
Perfect. Thank you, Julia. Thank you to everybody on the line as well. As Julia mentioned earlier, I'm Lindsey, so I'm the cyber development leader here at CFC Underwriting. As a preface to this, I don't claim to be a GDPR regulatory expert by any means. That's what you have Tim and Nick on the line here for. But where I really fit into this is just wrapping this up into an insurance context and talking about the implications of GDPR legislation and what considerations that needs to be made when you're considering including cyber insurance as part of your overall program, or if you have cyber insurance already, which well done, because you would make up about 10% of the UK market who is actually purchasing a policy, what you should be looking out for in your policy language as well. Just for context, for those who don't know CFC that well, we are a specialist insurance provider based in the City of London, but operating internationally in over 70 countries at the moment. And I think what we can really add value to in this conversation is how cyber insurance can support an organization, particularly with respect to GDPR. But I think what I'll be doing is really taking it outside of that context as well, GDPR is a very small component of what a cyber insurance policy can be there for as a business. I will go on to, of course, the hot topic that we tend to get asked is the insurability of GDPR fines and penalties, and perhaps I'll share our views on that as an organization. And of course, I don't think it would be any recent webinar or topic of discussion if we didn't bring up coronavirus or COVID-19 and cyber implications that we're seeing from our perspective. Certainly, there have been new attack vectors in the last few weeks. And there's been consequences from a frequency and severity perspective that I'll share some stories with you on. What stuck out to me on the white paper that was released, there were a couple of points. Number one, that fines do tend to be reduced when it comes to GDPR if there is obvious cooperation with investigations, and for businesses that are taking swift steps to identify the cause of the incident, and all of that response includes prompt notification of affected parties, prompt notification to the ICO, as well as the ICO more recently, especially with current circumstances, taking a more lenient view on cybersecurity and the measures that companies should have implemented where we're in a case that priorities might be elsewhere at the moment. So I do think that's a really good segue into where cyber insurance can actually fit into an overall risk management program. And I did share some statistics with you here today with a couple of takeaways from these. So what you've got on your screen right now, these are our cyber claims notified to CFC by frequency. There are global statistics as well. To put it into context in terms of how many we've seen, we've handled, as part of our internal cyber team, we've handled over 2,500 incidents in the last 2 years, just over 1,700 of which were last year. So if you do the maths on that, the large majority were from last year, which means that the trend is cyber claims are increasing year on year. And they are the global figures. I put the global figures, although I can absolutely share UK specific ones as well, but I was just conscious that we probably have some organizations on the line that have international exposures and locations outside of the UK. And it also gives you a more well-rounded perspective with a larger sample size as well. A few key stories there, and I'll eventually bring this back to GDPR for you. Number one, in terms of frequency, is certainly ransomware. And I think if you asked any other cyber insurer what they were seeing, I'm certain that would be the most rapidly changing one in terms of frequency of ransomware events happening. Ransomware events have always been associated with severity-driven losses. And a good example of that is ransomware affects your systems. An employee clicks a link, installs malicious software onto your computer systems, and it has a systemic knock-on effect onto every computer that's working over your organization's network. You lose income for each day that you're out of business as a result of your systems being down, potential reputational harm effects. There's some supply chain issues as well. So you can see how it can get large quite quickly without even factoring in the cost of the ransom payment itself. But now what we're seeing is that actually change into a frequency-based event where people aren't discriminating as to what size of industry you are or what industry you are, full stop, in terms of what your business activities are, and just really doing more of a spray and play approach where they try to get a lot of people in the crosshairs of clicking those malicious links. What is a bit scary recently in terms of ransomware is the crossover with data breach and privacy incidents that we started to see with more recent variants of ransomware emerging. Certainly in the last 6 months, anybody on our cyber incident response team would be able to talk to you about a variant of ransomware called Maze. And Maze is probably familiar to a few people on the line if you've heard any of the recent ransomware cases in the press recently in 2020. But Maze is most well known for being a variant of ransomware that will actually exfiltrate your data. And instead of holding you ransom for a financial amount, in order to ensure that you as a business actually pay that ransom, they'll threaten to release small portions of your confidential information in order for you as a business to pay the ransom, rather than make the decision as a business to not pay, and rather just restore your systems completely from scratch. Under the attitude that most businesses have is that you don't want to feel cybercrime, and that's the rationale for not paying. So that brings into additional implications with notification, certainly forensics, where you do have to actually have experts go into your systems and determine if any of that data has actually been exfiltrated or accessed by third-party threat actors. And of course, if it is determined that they did have access to that information, then you would be subject to the GDPR guidelines as well. So while ransomware was primarily a business interruption issue in the past, it's very much a privacy and notification issue now. More recent variant of ransomware as well, just on the topic of our number one driver by frequency of claims, is a new variant of ransomware called Ryuk. Ryuk isn't too different from variants of ransomware that people will be more familiar with, other than the fact that it tends to request ransom amounts at a minimum of 1 million. So if you mentioned to anybody on the response team a couple of years ago that the demand for ransom being made was in the millions, they would most certainly laugh it off and say that that's an uneducated cyber criminal who is asking too much and certainly isn't going to get that reward out of it. Now, if we hear anything under the 1 million mark with the prevalence of this and the threat of release of confidential information, then that's a good news day for the claims team. So just various trends to watch out for with that. 99% of the time that those events happen, they're as a result of human error, which Tim and Nick touched on earlier. And that, again, is something that can't be prevented by having best and brightest systems in place. It's absolutely human error and clicking malicious links.
Lindsey,
the other one,
Lindsey, can I don't know if this is the right place, so please carry on and answer at the end if it's not, but questions just come in about COVID-19. There's a surprise.
Yeah.
COVID-19 has brought about increased exposures for organisations migrating a remote workforce. When you're sort of talking here about claims, perhaps you could sort of, as you talk through, what the implications you think this might mean for business during this time. Do you see a flurry of cyber claims particularly coming in that might be related particularly to remote workers?
Yeah, an excellent question and very topical as well, of course. I think, you know, if you ask any one of our 30 cyber underwriters at the moment how busy they are, they'll all tell you very busy, because what we're starting to see are companies are recognizing that exposure they have in migrating from an office environment to remote exposures, and recognizing that the implications that has in terms of them being able to monitor what employees are doing from home, what devices they're using from home as well. More importantly, taking personal laptops as an example, they tend not to have the same security credibility as you would expect an office device to have, whether they're accessing company networks through RDP, through remote desktop, which most of us do, was already pre-COVID-19, approximately 80% of our cyber attacks were happening via RDP. So the fact that we've now got 100%, almost of the workforce working remotely, and most of those accessing networks through remote desktop, I think that's something to be very conscious of as well. And I was talking to our cyber claims team this week to ask them that exact same question, and I ask them every week that question just to get an update, as the landscape does tend to change fairly quickly on cyber generally, yet alone now. And it's interesting to see a couple of their thoughts. Number one, in terms of types of attacks they're not seeing new types of attacks per se, as in there's not new ransomware variants being made. There isn't a type of cybercrime that's happening that we didn't already know about before, but the success rate of them is certainly increased, which is leading to an increase in claims and notifications, and that's a result of first and foremost playing on human vulnerabilities. So you have an entire population of people right now who are dying to hear more information on what the latest statistics are with death rates in the UK as an example, or who are the most vulnerable populations. And so cyber criminals, unfortunately, are playing on that fear and creating things like COVID-19 maps, where they have malicious links embedded into them. Equally, we've seen them pose as government agencies. There's a good example in the UK where they were sending text messages to people stating that they were caught leaving their house at a time that that they shouldn't have been in accordance with the lockdown guidelines. And then it redirected them to a link where they were then to enter in their banking credentials so that they could pay a proposed £35 fine. Similarly, worldwide, we've seen a lot of cyber criminals pose as health agencies as well, with malicious links involved, and going as far as to even embed security features that look very real to sort of add to the authenticity of their websites as well. So it's not so much that it's new variants of cybercrime as it is playing on new vulnerabilities of people who are more likely to click a link in this situation. At CFC at the moment, you know, just to add a bit of a story to that, we've got a professional services firm that we're dealing with, quite a large company in the hundreds of office locations, 4,500 employees across the country. And by no short of a miracle, in one day, they were asked to work remotely in accordance with guidelines. Most companies were sending their workers home that day. So they were able to actually get 4,500 different laptops for all of their employees that day. In that time, in a 2-week span, that company was so focused on making sure that 4,500 employees were able to actually access the network and work remotely that IT security took a bit of a back step, you know, and similar to what the ICO has responded with having more leniency to companies where priorities have focused. You know, in that 2-week gap where IT security wasn't as enforced as strictly as it perhaps would have been in the office environment, the priority was to get people to actually be able to work remotely. In that 2 weeks, somebody had clicked a malicious link. And because all of those computers were operating over the same network, there wasn't any segregation between them. It had a knock-on effect across the entire company, meaning that they've now got 4,500 employees that are sitting at home with encrypted laptops that aren't able to access the company network at the moment. And this is now 2 weeks later. So you can imagine the financial impact that will have for a business, but certainly more importantly, the remediation and the incident response looks very, very different from a remote work perspective than it does in an office environment where it's likely been tested and tried out several times.
Okay, thank you. Now you've got one more slide. I'm just going to give you a couple of minutes to that, if I can, Lindsay, because I'd like to just ask one question and go around the table to all three of you to answer that question. So thank you.
Sure. Just on this slide, I thought it was important to share, just to show where these claims are coming from. I talked a lot about ransomware, but you would have also seen theft of funds there. You would have seen data breach phishing, which is primarily business email compromises, Microsoft Office 365 being synonymous with a lot of those. But to break it down more broadly speaking, if you do have one takeaway, cyber insurance policies are historically associated with being cyber liability policies. We know that because most of the market still call them liability policies, but what they are in reality and the way that they operate is on a first party expense basis. So the costs that are being used by an organization are on incident response, it's for their loss of income, it's the forensics, it's the legal costs, the cost to essentially ensure that you're handling the incident appropriately in order to help mitigate everything up front, to mitigate a potentially severity driven loss down the line that might be in the form of a liability or a regulatory action. So our third party claims are 4% of all the claims activities that we see, which includes regulatory action, including GDPR fines and penalties. And interestingly, being a global statistic, it's even 4%, in fact, less than 4% at this point. In the US, which is arguably a much more litigious class action culture than the UK does. So I just thought that was an interesting takeaway. It's really what cyber insurance brings to the GDPR landscape is the cost to actually handle a GDPR incident and have a coordinated response to that approach.
Lindsay, that's a really interesting slide to finish on. Thank you for that. And thank you again for being with us today. I'm going to ask you all one question. You get one sentence to answer it in, okay? So challenge from me. And I'm going to ask the question first to Lindsay and then go to Tim and then go to Nick. And the question is, what makes a GDPR claim different?
Interesting one. I think
1 minute. one sentence.
In terms of what makes it different, I think the fact that you have so many considerations as a business to make, and you have to make sure that you do it in a swift manner. The 72-hour provision doesn't leave a lot of time for an organization, but relatively speaking to a ransomware event leaves a lot of time for an organization. So preparedness in dealing with that and making sure you know the right people to call at the right time once it happens is going to help levy any potential fines down the line with GDPR.
This gets harder, by the way, Tim and Nick. So, Tim, 1 sentence.
I think for us it would be simply that the sort of technology tends to outpace law and regulation. So, sort of trying to keep up with how the people are working, how tech's operating, is a real challenge for sort of legislators and courts. So we're always sort of following up in the aftermath.
Thank you. And you definitely get the most difficult job, Nick. 1 sentence.
It's quick, and the damage can be exponential, and therefore it's a good idea to have the telephone number of your cyber incident response service on the fridge there, ready for you to call the moment it happens.
Unless if you're watching Killing Eve that you've got a spy listening into your fridge magnet, then you could be in trouble. And we're going to have to ask you to explain the reference to Hotel California. People of a certain generation know what that means, but probably anyone millennial or younger might well not. So answers on a post. Look, I just want to thank you all very much indeed. A hugely informative webinar today. Thank you, Tim. Thank you, Nick. And thank you, Lindsey. Super panel. And we're really proud to have both BLM and CFC as Airmic partners. And what a great job you've done today. I'd also like to thank those of you who dialed in today and joined the webinar. We had a super group today. And don't forget to have a look at the white paper. BLM and CFC have helped put that together, and we'll be posting that up on our website for those of you who couldn't be with us here today. So without further ado, thank you very much indeed. Stay well, stay safe, and see you soon.
Cheers. Thank you. Likewise.